One of the core purposes in the approach that we've taken in conducting our court proceedings is to demonstrate some very strong cognitive phenomena that we say conclusively influence the way proceedings are conducted. One of them in particular is the concept of the dual configuration in which the brain operates. It is now a scientifically accepted fact that the performance of the human brain can be represented as if it were operating in two systems, which sometimes operate concurrently. System 1 and System 2. System 1 is the more instinctive, reactive part, which basically works on autopilot. System 2 is the more deliberate, analytical part that consumes a lot of energy. The judicial system functions on the premise that the judges and jurors are always operating on System 2, whereas the extent to which people can operate in System 2 depends on their genetic predisposition and also on the extent of training that they've received, generally in their formative years. There has been considerable scientific research on the subject. I am referencing both contemporary books about judges and jurors, which are critical of the presumptions upon which the judicial system operates. I'm also referencing the scientific studies about core phenomena, which we say are implicated in the malfunctioning of the system. So that's one thing. The second thing is that there's a theory called the social contract theory, which basically stipulates that the way the brain is configured is such that there are two nodes where logic is processed. One node processes logic that is purely abstract, so mathematical logic, let's say, and another node processes logic that has to do with social justice and equity in human interactions. The two can concurrently operate on the same subject at the same time, but it is highly unlikely because what generally happens is the part of the brain that processes logic concerned with social equity and justice, which is the more reactive part, will come to a decision before the other parts is time to process things. This is different from the System 1 and System 2 thing, which was about whether a person reacts instinctively or whether they are calculating things scientifically before making decisions. The other part about the difference in the way logic is processed is that it leads to further reactions from people based on the inferences that they've drawn, especially when it comes to social justice and equity issues. I'll give you an example. Let's say you have an experiment where judges are assessing whether or not a group of people is complying with a set of rules. Let's say one out of the three rules that they're enforcing accords with people's sense of right and wrong. So let's say the people are supposed to observe the interactions of 10 people. The first rule is that every time they observe someone making eye contact with another person, both people need to immediately look the other way. The second rule is that if someone punches someone in the face, they must apologize for it. The third rule is that if someone uses the word abstract in conversation, then they have to pause for 30 seconds before using next word. Now, it wouldn't surprise anybody that once people are told about these rules, it's much easier for them to enforce the second rule versus the other two rules. It's much easier for them to remember the second rule as well, which is that if you punch someone, you have to apologize to them. This is because over the millennia that we've spent living in our current species, we have been conditioned to accept and comply with some basic rules of etiquette. That feeling is very strongly embedded in people genetically. So everybody finds it offensive when people just punch someone because they can get away with it. And in an experiment where punching someone in the face was okay, people will still struggle to accept that. Because the part of the brain that processes the abstract logic is different from the part that processes the logic in relation to social interactions. The problem this poses for the judicial determinations is that the law is supposed to be abstract in great part. The enforcement of the law is not contingent on whether or not the morally consistent with what people's core beliefs are. Some laws, which are purely formal and statutory, do not operate in a context where there are victims or people who are cheating and getting away with it. Jaywalking would be an example. It's more about a policy that the government is trying to enforce. The second situation is where people have been wrongly accused of certain things. It's only through an exhaustive examination of all the evidence that someone can make out that the person was innocent, or that the system had fulfilled its burden of meeting the relevant evidentiary standard. In order for people to do that, they have to use a different part of their brain. But the problem is that the part of their brain that processes social justice related matters overrides that. It prevents them from seeing it in an abstract sense, which the law presumes that they will do. The other problem with people in terms of fundamental incompatibility with fulfilling a judicial role consistently is that as they are deprived of energy, their tendency to go back to instinctive functioning increases. There was a famous study conducted in 2020 or thereabouts, which followed several dozen judges at the highest criminal appellate court in Tel Aviv. The study was coordinated through the faculties at Harvard and the most prestigious university in Tel Aviv. What the researchers did was they examined these judges as they considered parole applications for people convicted of some of the most serious crimes. They found that there was a consistent correlation between the time of the day an application for parole was heard and whether or not it was successful. So applications that were heard first thing in the morning had a much higher rate of success compared with applications that were heard just before lunch. Applications that were heard just after lunch had a much higher success rate than applications that were heard just before the end of the day. The only criterion that they could identify to explain the observations was that the blood sugar level was influencing whether or not the judge's brain would allocate enough resources to basically critically examine the process that was undertaken.